On December 7, 2024, just before the market opened for the winter charity drive, I was told that Rosa Delgado handed Daniel Mercer a roll of tape and pointed him toward the corner leg of a produce table that still leaned a little from the day he hit it. He took the tape, fixed the leg, and stepped back without saying a word she did not ask for. That image is why I am still talking about this case. Let me go back to the beginning. What stayed with me was not only that he lied to me in less than 15 seconds, it was that I felt anger for what he had done and tenderness for what he might still become in the same exact moment, and I did not know yet how those two feelings were going to live together inside one ruling. I want to ask you something before I keep going. Have you ever seen someone tell the truth late enough that it hurt, but still felt relieved when it finally came out? Subscribe. Because that is the kind of truth this story carries, and I want you here when it reaches the part that changed me. The sorrow in this case began at 7:12 a.m. on Monday, March 18, 2024, at the corner of Washington Street and Empire Street in Providence, Rhode Island. Rosa Delgado was setting up her sidewalk produce stand before the lunch crowd. Daniel Mercer was backing a white Ford Transit van into a loading space. He turned too sharply, clipped the side of her stand, and sent one full table down on its side. Oranges rolled into the gutter. Strawberries burst open under a wheel. Rosa reached to stop the frame from falling and took the force in her left shoulder and hip. A witness said she called out for him to stop. He got out, looked at the stand, looked at her, and said, "I barely touched it." Then he got back into the van and drove away. That sentence belonged to the sorrow current from the moment I heard it, not because it was loud. It was not loud. It was worse than loud. It was small, flat. A sentence shaped to make harm sound lighter than it was. Rosa lost 11 work days. Her doctor restricted her lifting for 19 days. Her stand needed repairs. Her week collapsed in public. When Rosa came into my courtroom, she held her folder under her arm instead of in front of her, and I could tell from that alone that raising the arm too high still hurt. She did not ask the room to notice. She simply moved around the pain the way people do when they have no extra space in their lives for drama. During the hearing, Daniel's daughter dropped a crayon near Rosa's chair. Rosa bent down slowly, picked it up, and slid it back to the child. I saw that. Loss had not made her small. Daniel Mercer entered with his 8-year-old daughter because school had a delayed opening that morning, and he had no one else to leave her with. He was 34, tired around the mouth, work jacket still on, one cuff stained with what looked like drywall dust. The moment that showed me his full humanity had nothing to do with the charge. His daughter's shoelace came loose, and he knelt beside her chair and tied it carefully with both hands, shaking. I saw the father. I also had to see the man who saw an injured woman and chose himself first. My job was to hold both without confusing them. The first papers that crossed my desk were plain. Complaint for leaving the scene. Complaint for making a false statement during the related inquiry. Repair estimate for $1,860. Medical note. 6 photographs clipped together on the left side of the file. There was also a witness statement from a city bus driver and a request from defense counsel asking me to consider a structured sentence instead of a simple fine. Most people do not know that in a case like this I can ask for a pre-sentence investigation when I think the right sentence may need shape, not only force. That report tells me about work history, family duties, debts, record, and whether a person has ever managed to tell the truth under pressure before. It does not erase conduct. It gives me the full floor I am standing on before I rule. The lie itself came quickly. Too quickly. When Daniel first addressed me, he said, "I stopped and made sure she was okay, Your Honor." The clerk started the street camera video. 15 seconds in, the van struck the stand, paused, and pulled away, while Rosa was still bent over the frame with one hand already moving toward her shoulder. I did not need more. He had lied. The room knew it when I knew it. That kind of silence is different from ordinary silence. It lands all at once. If you are still with me, you have probably gone a little still yourself. The room around you has probably dimmed a bit because you are inside this one now. Subscribe. That kind of attention deserves the rest of the story. Subscribe and turn on notifications. From the bench, I watch entrances and reactions the way some people watch weather. Rosa's nephew stood one half step behind her but never crowded her. That told me she was supported without being managed. Daniel entered differently. His eyes went first to Rosa, then to the screen, then to his daughter, then to me. That order told me almost everything. He was afraid of the evidence. He was afraid of who had seen it. And he was afraid of what his child might understand before the morning was over. The sorrow current moved first through evidence that could not be talked down. The photographs showed bent aluminum, split wood, crushed berries, cilantro ground into a wet sidewalk, and a paper sign that read, "Fresh peaches," even though there were no peaches left on the table. The doctor's note was clinical and hard in the way medical language often is. Shoulder strain, hip contusion, restricted lifting, follow-up visit in 10 days. Then Rosa testified she did not use large language. People who have lived a hard morning rarely do. She said, "Wando, when he left, it was not only fruit on the ground, it was my whole week." That quote belonged to the sorrow current. I wrote it down. A sentence like that carries rent, groceries, bus fare, medicine, and tiredness all in one line. Her nephew put his hand on the back of her chair and left it there. That was all he did. It was enough. The grace current began later and in a different place. It began with a hardware store receipt from that same day, time-stamped 9:46 p.m. 2 packs of metal brackets, 1 blue tarp, 1 roll of duct tape, 2 bungee cords, Daniel Mercer's debit card. By itself, the receipt meant little. Then a coffee shop owner from across the street testified that after closing, he saw Daniel come back alone in the same van, park half a block away, and cover what remained of Rosa's stand so rain would not ruin the fruit she had saved. He did not knock on her door. He did not wait for praise. He did not fix enough, but he came back. That mattered to me not because it canceled the morning, but because it told me conscience had found him before court did. Grace is not a shortcut around harm. It is what appears when someone stops running long enough to see it clearly. There was one point in the legal process when I felt both currents in the same second for the first time. I was reviewing the camera clip again in chambers while the clerk matched the receipt to the witness testimony. On one page I had flight. On the next page I had return. I felt sorrow for Rosa and hope for Daniel in the same breath. I remember that because it is not a feeling a judge can fake, and it is not one a judge can safely indulge. It must be carried, not chased. Here is what I am offering. The rest of this story told without hiding the damage and without pretending mercy is cheap. Subscribe if that is what you want. I will keep going. The defense argued what a defense should argue. Counsel said Daniel panicked because he believed he was one write-up away from losing his warehouse job. He had borrowed the company van for an early delivery run and feared that an accident report would cost him both the van and the job. Counsel pointed to 7 steady years of work, regular child support, no prior leaving the scene cases, and the fact that Daniel returned that night with supplies instead of vanishing into the city and never thinking of it again. Then the defense said something I did not expect, and that belonged to the grace current more than to advocacy. Counsel looked toward Rosa before looking at me and said, "If this court gives him a way to repair the part he can still reach, he will not walk away from it." It was not a flashy sentence, it was a human one. It sounded like someone who had stopped trying to make his client look clean and had started asking for the chance to make him useful. Still, there were things the defense could not solve. A tarp at night does not lift a broken table in the morning. Metal brackets bought after dark do not change the fact that he watched a woman clutch her shoulder and drove off. The sorrow current contained facts no argument could smooth out. That needed to remain true all the way to the sentence. When Daniel testified, the first quote that struck me belonged entirely to the sorrow current. He said, "I saw her grab her arm, and I still chose the driver's seat." Nobody helped him with that sentence. No lawyer shaped it for him. It came out heavy and plain. Then came the quote that belonged to the grace current. He said, "I went back that night because I knew Rain should not keep punishing her for what I did." I wrote that down too. Then came the line that carried both currents at once. He said, "I lied because I was scared, but I was scared because I knew I had done something wrong. I wrote it down. I looked at it for a long time. Both things I was feeling were in that one sentence. I did not expect that. His daughter had been coloring on a legal pad during the hearing. When he said that line, she stopped coloring and looked at him with the kind of quiet attention children give to moments they do not fully understand, but know they will remember. That detail stayed with me because from the bench I could see two truths at once. A child was watching her father fail. A child was also watching him stop hiding. This case reached into a memory from my own life without asking permission first. I was a boy when a delivery truck clipped the stone steps in front of my parents' house on a rainy afternoon. I remember my mother standing at the doorway with a dish towel in one hand and rainwater on the front walk. The driver left. I remember that clearly. But I also remember that he came back after sunset with a mason and 2 bags of mortar. My mother did not forgive him with a smile. She stepped aside and let them work. I have carried that scene for years without speaking of it. This case laid itself beside that memory and stayed there. The point of convergence came during Rosa's cross-examination. Defense counsel asked her very gently what she hoped would come from the case if the court could order more than money. Rosa looked at Daniel for only a second and then back at me. She said, "He hurt me, Judge, but I do not want his little girl growing up thinking a man can live inside an excuse." That sentence carried both rivers at once. It held the harm steady and still made room for a future wider than punishment alone. I just realized saying that now that I had never repeated that sentence outside the courtroom before today. Subscribe. Because that realization matters to what happened next, and I want you here for the part where those two currents finally had to become one ruling. By the time I reached the end of the evidence, I had the street video, the photos, the medical note, the repair estimate, the vendor income logs, the hardware receipt, the witness statements, and the pre-sentence report. That report said Daniel paid support on time, worked 6 days most weeks, and had 1 older citation for careless backing, nothing more. It also said something I could not ignore. Under stress, he had a habit of lying quickly and then collapsing under the lie afterward. That is not a diagnosis, it is a pattern. If a sentence is going to mean anything, it must meet the pattern that produced the harm. Before I ruled, I looked at my hands. One was flat on the file, the other rested on the bench edge. Daniel stood rigid, not arrogant, just braced. Rosa had both hands over her papers now, not gripping them anymore. I had decided carefully. I had decided knowing this ruling had to hold the weight of what was lost and also leave room for what might still happen. Those two things do not always fit in the same sentence. In this case, they did. I had made sure they did. I found Daniel responsible for leaving the scene and for making a false statement connected to the incident and then repeating that lie in my courtroom. I said it plainly. Then I turned to sentence, and I spoke the way I needed everyone present to hear me. I am ordering you to pay $2,905 in restitution to Rosa Delgado. That money covers the stand repair, replacement produce, and 11 documented workdays lost while she was injured. This payment is meant to repair what money can still repair. I know money will not restore her shoulder or give her those mornings back, but bills created by your conduct should not live on her table. I am also ordering a fine of $600 with $300 suspended if you complete every condition I am about to set. I am doing that because leaving the scene and lying to a court do damage beyond one sidewalk. They injure trust. But I am suspending part of that fine because I want the law to leave you a reason to move toward discipline, not only a reason to feel crushed. I am ordering 26 Saturdays of restorative service beginning May 4, 2024, from 5:30 a.m. to 8:30 a.m. at the Kennedy Plaza Market area. You will unload crates, set tables, break down boxes, sweep, and do any physical setup work assigned by the market manager. If Ms. Delgado agrees, some of that work may directly assist her stand. I am ordering that because you left damage on the street. Your body needs to learn what it takes to put usefulness back where harm was left. I am ordering 12 counseling sessions over 6 months with a licensed counselor focused on shame, avoidance, and dishonest reflex under stress. I am naming those things because broad language lets people hide. I am not going to speak broadly to you. You did not lie because words failed you. You lied because fear got to your mouth before character did. That must be worked on directly. I am also ordering monthly review dates in my courtroom for 6 months. Each month you will bring proof of restitution payments, proof of counseling attendance, and one handwritten page explaining one thing you did that month to repair trust with another human being. Not something polished, not something borrowed from a book. One page in your own hand. I am doing this because accountability is not only about money and hours. It is about learning how to stand in the truth without decoration. And there is one more thing. Within 30 days, you will write Ms. Delgado a letter of apology, place it in a sealed envelope, and file it with the clerk. It will be delivered only if she says she wants it. If she does not want it, it will stay sealed. I am ordering that because apology belongs first to the person harmed, not to the comfort of the person who caused the harm. I am giving you one path to early completion. If by November 30th, 2024, you have paid full restitution, completed at least 20 consecutive Saturdays of service with no lateness, attended every counseling session, filed every monthly page, and committed no new violations, I will suspend the final 6 Saturdays and the remaining $300 of the fine. That is my way of leaving a door in the structure without saying more than a judge should say from the bench. Then I addressed him directly. I said, "What you did was not small. You injured a woman trying to earn her living. You damaged what she depends on. And when truth first asked something of you, you chose distance. Ms. Delgado paid for your fear with her body and her week. That is real. But you are not only the worst quarter minute you gave this court. I saw the father tying his daughter's shoe. I saw the man who came back with a tarp. I saw the man who finally said the true sentence out loud. Everyone in this room has now met both versions of you. The next version they meet is up to you. The plain fact is that harm does not stop being harm just because conscience arrives later." I want to stop here for just a moment, not for effect, because what I just repeated is something that still sits with me, and I need a second with it. Subscribe while I take that second. Subscribe and stay. All right, let me keep going. After I finished, the room did not release in the way people expect when television has taught them to wait for some grand response. Real courtrooms do not work like that. Rosa's nephew leaned down, picked up the crayon near his shoe, and placed it beside Daniel's daughter without looking for thanks. Daniel covered his mouth with one hand for a second, then lowered it and nodded once toward Rosa. It was not a performance, it was small. From where I sat, that made it more believable. Before I stood, I straightened the hardware store receipt at the top of the file and laid my palm over it for 1 second. That was all I did, but it came from the place inside me where both currents had finally met. After the courtroom emptied, Rosa said something to me in the hallway that was not testimony and not for the record. She said, "Judge, I can carry what he broke. I just did not want him carrying the lie forever." That quote belonged to the Grace Current. I have been carrying it with me. Cases end. Some sentences do not. What happened after matters to me more than many rulings ever do. On November 23, 2024, the Saturday before Thanksgiving, the market manager sent word to my clerk that Daniel had arrived before dawn again and had not missed a single service day. More than that, Rosa had finally allowed him to help arrange the front display where the best fruit went, not the bruised fruit, the good fruit. Her shoulder still bothered her in cold weather, I was told. The sorrow remained, but grace remained too. Both were still present in that one detail. There was an appeal, limited and plain. Daniel appealed the counseling condition and the monthly handwritten reflections to Providence County Superior Court. On April 4, 2025, that court affirmed the sentence and held that those conditions were tied to the record and reasonably aimed at accountability and repair. It took just under 4 months. When I heard the result, I did not feel victory. I felt steadiness. That is the truer word. This case showed me something I am still trying to understand fully. Holding two feelings at once is not always confusion. Sometimes it is the cleanest form of honesty available. I have seen people come into court desperate for me to choose one story only, monster or good man, victim only or witness only, failure or future. Life refuses those neat containers more often than law admits. There is one sentence I have never said in any other professional setting, and this case produced it in me. Sometimes I trust a late truth more than an early performance. I do not mean late truth erases cost. I mean that when truth finally costs someone pride, comfort, image, and excuse, and they say it anyway, I listen for what might still be built after the damage is named. If you know the sorrow side of this story, if you have been the one injured and then asked to prove it while still hurting, I want to say something careful and true. I saw in Rosa's face the tired dignity of someone carrying pain and still refusing to let pain decide the whole shape of her character. Over the course of those proceedings, I watched her remain more than what had happened to her. The harm did not erase her judgment. It did not erase her standards. It did not erase her. If you know something of the defendant's chair, if you have made a real choice that caused real harm and now wake up inside the question of what comes next, I have watched people move in two directions from that place. The ones who move towards something stop editing the story to protect themselves. They say the whole sentence. Then they do the plain work long enough for other people to trust their hands again. What I wish I could say to every person in that chair is simple. The truth will cost you once, but the lie will keep billing you. You just heard what I said to him in that courtroom, and you heard what Rosa said to me after it was over. Hold both of those lines. Subscribe before we go further, because what happened beyond the sentence is the part I return to most. I return to that winter morning image because it is so small no one would choose it unless it were true. Rosa handed Daniel a roll of tape and pointed him toward a crooked table leg. He fixed it and stepped back. She did not smile for him. He did not ask her to. Nothing in that moment erased March 18, 2024, but something in it proved that accountability and grace can stand in the same cold air without canceling each other. I also returned to her hallway sentence. I can carry what he broke, I just did not want him carrying the lie forever. I hear that sometimes when I'm alone after court, not because it lets anyone off the hook, because it tells the truth about what justice can be when it is done by human beings who are willing to feel more than one thing at a time. That is why I told you this story. Subscribe and stay. In the comments, speak like people who understand that hurt and hope can sit at the same table without one of them leaving.